Good afternoon, everybody. My name is Chris Justice. I am an associate with Samfiru Tumarkin. And as many of you may know, I'm here today to hopefully answer as many questions as I possibly can with respect to all things relating to employment law. So definitely get your questions in, whether they have to do with something on your way into a working relationship, maybe something on your way out of a working relationship, or maybe you're just going through some issues during a working relationship itself. But either way, you definitely want to get your questions in when you can. And I'm here to hopefully answer as many as I can. So before I get into some of the topics or some of the questions that you may have for me, I wanted to start off with a couple of topics off the top, as I usually do. One topic I wanted to talk about was with respect to some changes that have been happening when it comes to artificial intelligence. As many of you know, a lot of companies are implementing AI in various different capacities, as well as sort of looking to change existing employees' relationships with that company as far as that AI is concerned. So, for example, when the AI comes into play, I know a lot of people are losing their job, and the AI is effectively replacing that person's job. Or in some other cases, AI is being implemented in the workplace, but the person isn't losing their job per se, but there are changes that are happening to their job as a result of AI coming into the fold. And a lot of people have been coming to me asking me about, whether and to what extent they have any rights when it comes to AI replacing them or their duties. And if it has to do with a termination, if you're somebody who has a job and they have, or you've been let go as a result of AI coming in to effectively replace your job, then there isn't going to be a whole lot you can do to prevent that termination from happening in all likelihood. However, if you've lost your job because of AI in some form or fashion, that doesn't mean that the employer can let you go and not pay you anything on your way out. The company would still have to pay you your full severance. That would still be a without cause termination. And you definitely want to make sure that at least you get a fair and reasonable severance package on top of maybe other compensation or aspects of remuneration. If you're somebody who has been in an employment situation and AI is coming in and maybe you're not losing your job, but you are noticing some changes that have happened to your job, then there could be an issue there. You may have actually an option to respond to your employer and say that they don't have the right to make these changes, even if it is being done on good faith, even if there is some sort of business mind behind the changes. If your job is changing, as a matter of fact, and if those changes are significant, regardless of whether they're being done in good faith or bad faith, just know that you have an option as an employee to either accept those changes, potentially negotiate those changes, or refuse those changes and tell your employer that you had signed up for a particular role for a particular job, doing particular duties, and that's what you're agreeable to doing. But if they're going to come in and insist that, say, half of those duties get taken off of your plate, then, as I say, you as an employee can sort of draw a line in the sand to say that this is not acceptable. And if you're going to insist that my job change in this drastic way moving forward, then I'm not agreeable to that. And then you could pursue a potential constructive dismissal case. Now, before communicating anything like this to your employer, you definitely want to get some legal advice. You want to contact us. You want to discuss with us how you can best communicate with your employer. And this, I'm talking in the context of AI, but really, as far as there being any changes at all to the terms of your employment, whether it's AI related or not, you're going to want to get some legal advice first before communicating with your employer, because depending on what you say, could actually help you or potentially hurt you as far as any future rights you have. But important to know that significant changes being made to your employment that you did not agree to or sign off on would normally be considered a constructive dismissal, which then affords you the same entitlements, the same compensation and rights as though you were let go. So as I say, I'm saying this in the context of AI being implemented in a lot of workplaces, but generally speaking, as I say, any changes like that can afford you those options. I've got another topic I wanted to chat about off the top before I get into some of the questions, and that had to do with employees being placed on temporary layoffs. So as we know, back when the COVID pandemic had started, a lot of people were getting laid off that had never been laid off before. And the big question at that time was whether or not, in the context of COVID and the pandemic, whether or not companies had the inherent right to place somebody on a layoff. And the answer to that question is no. Employers do not have an inherent or general right to place somebody on a layoff. Again, even if it is being motivated in terms of good faith and no one's being targeted per se, maybe the business is suffering from an economic downturn and has made the decision to lay employees off, that can be understandable. However, from a legal perspective, employers still don't have that general right to put somebody on a layoff unless there has been some acknowledgement from the employee that they're agreeable to it. Some contract maybe that the employee has signed that says they're agreeable to being placed on a layoff, depending on the situation, or unless the employee otherwise communicated to the employer that they were okay with being put on a layoff. If those things happen, or perhaps as well, there's maybe a history of layoffs. If any of those things are applicable, then your employer may be able to place you on a layoff, but otherwise, as I say, they don't have that inherent right. And for an employer to put somebody on a layoff without that ability or right to do so, just like making big changes to the employment itself, putting somebody on a layoff can constitute a constructive dismissal, and it can result in you being entitled to your full severance. And if you are entitled to your full severance, whether it's because you've been placed on a layoff without your consent, or maybe it's because your job has changed as a result of AI coming in, or even been eliminated as a result of AI coming in, you're going to have those options to get your full severance. And depending on how old you are, depending on how long you were at the company, depending on the position that you held with the company itself, you could get as much as 24 months of severance. So just know that. And certainly whenever you're looking at a possible severance offer being sent to you by a company, maybe you're thinking it's a fair and reasonable offer. For the most part, most offers that I see given to employees, especially in the first instance or in the early goings, those offers aren't anywhere near what a full common law severance package would look like. And you should absolutely get some legal advice before signing off on any termination package, any severance offer, regardless of how good it may seem. Because if not, then hindsight might be 20/20, and you may find yourself essentially having accepted an offer that is much less, tens of thousands, if not more, dollars less than what you could have got. So with that said, I've got a couple more topics I'll touch on if need be, but I did want to get into some questions. I've got a question from Mark on Facebook. Mark is saying that the small business that Mark works for has been sold, and the new company has offered Mark a job at the same rate of pay. And Mark is asking what kind of severance, if any, is he entitled to? So this is a good question. It's good in the sense that a lot of times companies are bought and sold, and employees either lose their job as a result of that purchase and sale, or they get offered employment with the new employer. So if the purchase and sale happens, first of all, and you're an employee who does not get hired on to work with the new company, then technically your employment would have been terminated by the business that was sold, and you would be owed severance from the seller of the business. And so, depending again on how many years of service you put in with that previous company, depending on how old you are at the time the termination took place, the position you had, as I say, you could get upwards of 24 months, and in this situation, it would be from the seller of the business. There's another scenario, much like what Mark's involved in, where you aren't let go necessarily from the business that sold itself to somebody else, but rather you're offered a job with a new company. The company is interested in continuing on your employment. And as long as the company that is looking to continue your employment offers you a package or a set of terms that are similar or comparable to the job that you had with the seller of the business, there is going to be a general obligation on you to continue working for that company. However, if you are being asked to maybe sign a new contract with the purchaser of the business, or you're being asked to continue working for the purchaser of the business, but on different terms than what was the case beforehand, then you may be in a situation where you could have some options. You could potentially consider your employment to have been terminated as of the day you were told to move over to the purchaser, especially if there's big changes made that were not present to begin with. Or if you're not going to go down the termination path, it'll kind of come down to what the terms with the new company are. So the more different they are, the more likely you have the option of continuing on with that company under those different terms, or leaving and getting some payout. And then the less significant they are, generally there's going to be maybe less of a leg for you to stand on, or less options as far as whether or not you want to take on that new job or not. Because if the purchaser of the business offers you the exact same role that you had with the seller of the business, and you turn down that role, you may very likely be seen as having essentially quit your job or abandoned your duties. And that could affect the potential that you would have for severance as far as your best case scenario is concerned. But as I said before, it'll always boil down as well to, your age and length of service, the position that you held, as well as whether or not you've signed a contract beforehand, and maybe what that says in the context of a termination. So something you definitely want to get legal advice on as well. I've got another question in from Chantel on Facebook, who's saying that they think they may need to quit their job, that as their employer has stopped giving them accommodations for their special needs child. And Chantel's wondering if there's anything that they can do about the situation. So anytime an employee asks for accommodation for something to do with human rights related reasons, so it could be a disability, could be some family related reason, taking care of a special needs child, for example, could definitely qualify. Anytime there's a request for an accommodation like that that's made, the employer's duty is to give its best efforts in trying to accommodate that accommodation up to the point of what's called undue hardship. So there's always a limit to most things, and employers, there is going to be a limit as far as how much accommodation an employer needs to give, but the bar or the threshold that an employer needs to meet before it can say it shouldn't be required to go any further is quite high. And I find that a lot of times in my experience, when employers are considering whether or not to accommodate somebody, a lot of times they think that just because the accommodation may require some cost or inconvenience to the employer itself, that they're less willing or not willing to provide that accommodation. And that's typically not the test. Just because there's some inconvenience or even financial cost to accommodate somebody's, say, disability or personal situation, does not mean that the employer can just simply get away with stopping to provide any kind of accommodation. And it could very well be the case in your case, Chantel, that the employer has failed in its duty to accommodate, that the employer has not done everything that it can to the point of undue hardship to accommodate your needs. And if that's the case, then the employer will be at risk of having breached its duty to accommodate under the Occupational Health and Safety Act. And that in and of itself could therefore constitute a termination. And then you would be looking at your full severance rights as though you were let go. Not to mention, because your accommodation involves looking after a child and involves human rights concerns, the employer may not only be on the hook to pay you out your full severance for not accommodating you, but also be on the hook for having to pay additional damages for failure to accommodate in relation to the human rights protection. So there could be a lot at stake there. And I would say, Chantel, or anyone in that position, you definitely want to give us a call. You want to get some legal advice before sending any resignation letter or email in, because you could actually do yourself more harm by preparing a resignation letter and sending it off to your employer before getting advice. So as I say, you want to get advice. You want to make sure that before you send anything in writing, that you get that legal advice, that you for sure mention the fact that it has to do with the failure to accommodate. But all of that would be discussed in a consultation with the lawyer. So if you're in this situation, as I say, give us a call. But it's a good question to bring up because unfortunately it does happen far too much even still today. So thanks for the question, Chantel. I've got another comment from Woodwork Maker on YouTube who's saying that they were let go after a coworker, I guess, accused them of making an inappropriate comment. The person asking the question, Woodwork, is a 13-year employee and never had a complaint before. There was no severance, and they're asking whether there's anything they can do. So it's a good question. Again, a lot of times people, even if it's true, whether they engage in some form of inappropriate conduct or misconduct, even if that's the case, for the most part, and especially for a 13-year employee with no complaints before, they're still entitled to severance. There has to be a lot of, misconduct or a lot of issues going on with the employee and a lot of chances being given, but there just being no improvement generally before an employer can let somebody go and not pay them any severance. So just like the duty to accommodate, the threshold for that is very high on employers. In order for an employer to get away with not paying anyone severance on their way out, there's also a very high bar that needs to be met. And so a lot of times employers will assume or think that they have cause to terminate someone's employment. Maybe they think that the conduct itself is bad enough that they can get away with not paying anyone severance, especially after 13 years. But the vast majority of the time, that's just not the case. And as I say, that's even assuming the misconduct happened. There are lots of instances where misconduct happens, but it's not enough to strip that person of their severance entitlements and rights. That the cause termination, when employers try to do that and not pay you severance, that is known as the capital punishment as far as the employment law world is concerned. And so, as I say, there needs to be a very high standard met before they can get away with that. So Woodwork Maker, definitely give us a shout. I think especially given the years of service and the unblemished record beforehand, there's a very good chance that you're owed severance. And as a 13-year employee, you could be looking at over a year of severance, which of course is a huge change from what's being offered right now, which is nothing. So thanks for that question. And I think it is important for people to know that you may think you're dead to rights. You may think you don't have a leg to stand on. You may think that they've got the evidence against you for committing misconduct of some form or nature, and that therefore means you're not owed anything. But that's just not right. And especially you may not even think there's anything wrong or that happened that was wrong. A lot of times there's a dispute, first of all, as far as whether any misconduct happened to begin with. And if your employer is going to establish that it has cause to let you go, it's got to be the one to prove that it has the evidence in support of that basis. But thanks again for the question. I've got another one from S. White on YouTube who's asking whether or not an employer can have the worker sign a liability waiver in case they have heat stroke in the warehouse so that the company will not be quote unquote liable. And is this legal? So this isn't something that I think happens too much. But I don't think that an employer is going to be able to get out completely from any liability in the event that their employers have heat stroke in the warehouse. First of all, employers need to make sure that the work environment is safe and healthy to begin with. And so if there's a work environment that could possibly cause harm to an employee, that in and of itself is an issue and is probably something that needs to be addressed. So I'm not sure exactly why they would try to have you sign a liability in the event of heat stroke, but that generally is not going to be enough to absolve itself of its duties otherwise to make sure that, as I say, the workplace is healthy, safe for people to work in it. And if you're being asked to sign some liability waiver and told that something will happen if you don't sign the waiver, then that's also a problem. So it's a question of, I guess, how badly your employer wants you to sign this waiver, and what, if any, threats have been launched or issued against you should you not sign the waiver. But in this particular case, I would definitely get some legal advice before signing anything. As I always say, it could be a liability waiver in relation to potential heat stroke, or it could be a waiver with respect to anything else. But the general essence is you are potentially waiving your rights to bring any kind of a claim later on, should something like that happen. And anytime someone puts a piece of paper in front of you asking for that, as I say, you definitely want to get legal advice. And again, if you're being sort of threatened in a manner of speaking that you might lose your job if you don't sign the waiver, and that's actually what happens and what your employer follows through with, then your employer could, as I say, be in more hot water as a result of doing that. So there's a lot to consider, but definitely give us a call if you're someone in a situation like that. I've got another question in from Andy B on YouTube, who's asking whether or not having a criminal record affects potential severance, in addition to the more general ones like your age and length of service, etc. So generally speaking, criminal record is not one of the factors that's considered. I guess the question would be, as a result of having a criminal record, does that affect how much time it takes someone to find another job? And did that person have a criminal record beforehand, or was that something more recently, I guess, incurred or obtained? But yeah, generally speaking, when someone loses a job, they are expected to make reasonable efforts to go out and find another job. And depending on who you are, what's reasonable for one person may not be reasonable for another. For example, you might be disabled in some way and not able to work. Of course, that's going to lengthen the time it takes you to find work, and that's understood. There are other situations where maybe not having a high school education could really affect your ability to find work, or maybe having a criminal record could affect your ability to find work. I think that the longer it takes you to find work, as long as the reasoning behind it makes sense and fits, that could at least be a factor in considering, paying you more severance for that extra time it took you to find work. So criminal record, not one of the highlights in terms of the main factors, but it could nonetheless affect your ability to find a job and lengthen that time. And depending on your case and how long you've been there and everything, that could lengthen the potential amount of severance you get. If not directly, then maybe indirectly. And Andy B is just following up saying that they were let go after 1 year and 8 months and that they're 56 years of age. Is that too short of service for severance of any significant amount? And I would say no. A lot of people incorrectly assume that because I'm with a company for maybe 6 months, maybe a year and a half, maybe 2 years, 2.5 years, that this short-term service isn't going to amount to much in terms of severance. So why bother? When actually there are lots of cases, lots of examples where employees have been employed with a company for only a matter of months, not even close to a year and 8 months, and they've still received severance packages in the range of 4, 5, 6 months. You add that to the fact that you're 56 years of age, there could be a little bump up there. So depending on all the other factors and your compensation and your position, Andy, as I say, you could get as much as 6 months in terms of severance. So that could be a lot of money, and probably is a lot more than maybe what you assumed could be the case as far as severance, which, a lot of people I know assume that because they've been there for less than a year, a little over a year, maybe they get 2 or 3 weeks, maybe a month at the most. But that's just, as I say, not always the case. And a lot of times short-term service employees actually get disproportionately larger packages than you would believe. So definitely want to give us a shout. Andy B had another question about whether or not the reason for termination is relevant if the employer chose to put without cause on the record of employment. And that's a good question. As long as you have been let go on a without cause basis, the reason for why you were let go is going to be a lot less relevant. Not to say it's irrelevant, because sometimes the reasoning can be motivated by bad faith or discrimination, and obviously that's going to be a huge concern. But assuming that those aren't the case, that's not true, employers have a pretty wide latitude to kind of let you go for any reason they want. The one caveat, though, of course, being that they need to provide you with a fair and reasonable severance package. And if they don't, then they could get themselves into a wrongful dismissal matter in that sense. But thanks, Andy, for your questions, and definitely happy to chat with you more about this later on. Or if you want to set up a time to have a consultation with someone at our firm, I would recommend that. I've got another question in from JX2 on YouTube, who's saying or asking, in the event that you leave or are terminated from a job and later that company purchases a company you now work for, how are your or the employer's rights affected in the event of a future ending? Okay, so let's just break this down. So you either leave, so you resign a job or you're let go from a job, and then the company that let you go purchases another company that's now your employer. I guess technically speaking, you would be working for that employer, even if they're owned by we'll call it the parent company that let you go. You would, I guess, have a new relationship with, say, the subsidiary company or sister or brother company. And whatever company that is, even if they have a parent above them, whatever the below company is, that would be who your relationship is with. So if you then lose your job with that new company, you wouldn't necessarily be able to tie in the years of service or the months of service that you had from the first company, but it would just depend on whether there's a break. So if you lose one job or you leave one job and there's several months that pass and then you end up working for another company that actually got bought out by the one that let you go, then you're probably going to be more likely to start fresh with that new company. And then that's just going to be based on that relationship. If you are leaving a job or let go for a job and immediately or very soon join a new company that's purchased or owned by that company that let you go, then there could be a chance that you could connect it all together as one continuous form of employment. That's possible. And if so, you'd be able to obviously argue for more severance if you can tie in all those previous years. But as I say, otherwise, it would just be dealt with in two separate instances. So one working relationship on this end, and then the subsequent working relationship on this end. And then, you'd get your rights that would be applicable for either scenario. I've got another question in from Tim on YouTube, who's asking whether or not federally regulated employers are subject to Human Rights Commission for accommodation requests. And yes, there is what's called the Canadian Human Rights Commission. So there are human rights obligations and duties that apply to those employers as well. A lot of people also incorrectly assume that maybe there's a difference between federally regulated employers and provincially regulated employers where, not all the same human rights protections are afforded, or not, most of the human rights protections are afforded. But that's not the case. There's still a general duty to accommodate. So again, if you're somebody who has been stripped of their ability to be accommodated, or you're being denied accommodation, or you're being told they can only accommodate half as much of what you're asking for, then you're potentially in another constructive dismissal situation with added human rights damages possibly being placed on top of that, plus a whole host of other damages potentially, depending on what your situation is. I'll take just one more follow-up from JX2 before I let everyone go. I've got JX2 is saying that they left the job in 2011. That company was bought out, and the parent company is buying out more companies. So yeah, JX, it seems like if you had left the first job in 2011 and then, let's say, joined up with another company who was bought out by the company that you left in 2011, but years later, because of that break in service, your employment's likely just going to be treated as a standalone, separate subsequent form of employment whenever it is that you got the more recent job. But having said that, again, I thank everyone for their questions. As always, I will be back to answer more of your questions. So definitely tune in next time. So yeah, bring all your questions relating to employment law. And as you see down below there, you can join us again live at 10 o'clock Pacific time for disability law question and answers with Martin. So if you've got questions relating to disability claims, long-term, short-term disability, maybe you're being denied by the insurer, maybe your employer's not doing its end of the bargain, Definitely Martin will be there to answer all your questions on the 25th. But as far as today's concerned, thanks again for joining us, and have a great rest of your day. Take care. Bye for now.